Good morning, sir. You're Dan Church,
Oh, yes, ma'am.
and this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm, and the state has filed a motion asking that well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge, that's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant. And I'll fill the court in on that as to why I don't have a witness present.
looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error.
That's
Obviously,
fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. No, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing, and I have a Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with complainant, not possessing any weapons.
Those are already conditioned.
Right. I'm not sure what else, what else the court could impose, because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's, hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
No, I think
that I'm aware of,
concern is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations in the probable cause, that would give me some concern too, if I lived across the street and that had actually happened. So,
But I don't think, I just don't think raising his bond and discharging him, which any is a question, is the proper remedy for that. So I'm not sure how the court remedies that. And I
well,
don't see what
the
that.
way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you know, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you, here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand? So if they feel uncomfortable, they're going to let Miss Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense? Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay? You're free to go.
Thank you.
Oh, here. One of those is just what I printed out. Do you want the exhibit or does that go in the file? Good morning. You are Amber Bruno Walker. And this is cause number 25 DCCR 1814. Ms. Bruno Walker was previously in court, entered a plea of guilty to the state jail felony offense of driving while intoxicated with a child passenger. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have your honor.
The state has, Judge.
Are there any additions or corrections?
None from the defense, Your Honor.
No additions or corrections. However, I do have a comment or a question,
Sure.
and it relates to the defendant's version of H2. Your Honor, I don't know that it's a full-throated admission of guilt. She refers to this incident as being a distracted driving incident, when in reality it was a rollover crash. She was essentially not cooperative and required a blood search warrant to get her blood.
I made note of that as well.
Judge, I would add to that though, is, she did acknowledge in that same thing, although it's not lengthy that they listed, she did also acknowledge in it that this was her responsibility. She said responsible for.
I mean, you tested your blood alcohol by the time they finally got it was 0.0986.
Yes.
I mean, so you definitely were above the legal limit. Are you disputing that?
No.
Okay. So Ms. Bruno Walker, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated on for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. So you're going to be regularly tested. The police version is that it rolled over.
Yes, ma'am, we did.
It did not roll over. Okay, that's just so
Just so the record's clear, Judge. I've got a photo here. I'll show it to Mr. Rennick as well.
okay. How's that not a rollover?
It's not. It doesn't, it's nothing to do.
I thought rollover mean like.
Well, it wasn't on all four wheels, was it?
Yeah.
while you had a child in there. So here's part of the important thing about probation is in order to be successful, you've got to completely take responsibility for everything you've done, all of the conditions that you're going to have to do. It gives me some concern that there's some diminishing of that by you right now. So it is very important that you take advantage of everything that you're about to have to do on probation, because if you don't, you're going to be right back in here and you're going to be looking at that 2-year sentence. You understand? So you are, do you currently have the auto ignition device on your vehicle?
Yes, I do.
Okay, so you'll make sure and keep that. Obviously, if there's any blows into that are positive for alcohol, it's a violation of your probation. If there's any issue and probation feels like you need anything more than just regular probation, you'll immediately be referred to treatment, whatever that is. It will be ordered by the court. You understand? You can't have a single drink of alcohol while you're on probation. And obviously you can't do anything else, whether it's legal or illegal, without a prescription. If you do everything you're supposed to while you're on this probation, this is a
This
great
exchange right here is exactly why judges often pay close attention to a defendant's attitude during sentencing and probation hearings. Notice how the judge keeps focusing on accountability. The issue is no longer just about whether the vehicle technically rolled over. It's about whether the defendant fully accepts responsibility for putting a child in danger while allegedly intoxicated. Courts tend to view minimization very negatively, especially in DWI cases involving children. And the judge is practically spelling it out. Probation is an opportunity, not a guarantee. If the court senses someone is still downplaying the seriousness of what happened, that can become a major red flag moving forward. Also, the ignition interlock warning is huge because even one failed alcohol test could trigger a probation violation and potentially send her straight to jail. This is the kind of situation where every single decision after sentencing matters.
This is a great opportunity because you'll be able to serve that 2-year sentence that you received while you're out on probation instead. But the other side of that is if you violate any condition of probation, you could be brought back into court and you could be your probation revoked and facing that 2-year sentence. You understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. All right, you just need to have a seat here in the courtroom. Yes, ma'am.
Occupational.
Talk to your attorney about that. That's filed somewhere else separately from this. And so have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thank you.
Judge. Thanks.
Morning. Good morning. So this is Miss Malfino. Miss Malfino on Regina Williams. Good morning, ma'am. You're Regina Williams. And this is 26 DCCR 0218. And what is the announcement?
Your Honor, she's informed me has documentation that she's supposed to provide today. Which I think will resolve the case if it says what she says it says, but I have not seen it. She told me she can have it today, and I'm asking for like a 2-week reset.
So why haven't you gotten that to Mr. Parker already?
Because the people didn't meet me to sign the affidavits at the notary, but they said that they'll meet me today.
Okay, so I'm gonna do about 2-week reset.
Yes, ma'am.
Well, let's do this. I'll just do a normal reset, okay? Get that as quickly as you can to
Yes,
Mr.
ma'am.
Parker because he needs to get it to Ms. Malfino so she can take a look at it, and then it may or may not make a difference in your case, but she'll take a look at it once that's done. If for some reason that doesn't happen, then when we come back, we'll need to do something with the case, okay?
And Judge, if I may, just to reiterate what the court said, based on her prior criminal history, it's not likely that that affidavit's gonna suffice.
Okay.
But I'm happy to take a look at it, but I will make 2 alternative offers.
Okay, thank you. So
Thank
make sure
you.
you visit with Mr. Parker before that next court date as well. Okay, thank you.
They say I have another one, but I don't have the bond. I
I
don't.
don't have anything else.
Okay.
Good morning. You all right, Mr. Gray?
I can't have it.
You okay this morning? Why are you sleeping?
Work.
Work. Have a seat in the jury box. I'm gonna get you tested this morning to see if there's anything in your system. Mr. Lewis, you've got Treasurer Harris. It's a sentencing.
Second seat, back row.
Good morning, sir. You're Christopher Rhodes?
Yes, ma'am.
This is 26 DCCR 0209, and Mr. Rhodes is charged with driving while intoxicated with a child passenger. What is the announcement?
We have an agreement, but they need to re-indict him. And so I think Mafia said a couple weeks or
Judge, he provided the mitigation documentation this morning to allow me to re-indict this to an endangering from a DWI child passenger
Okay.
so that he may receive deferred. I could have it indicted on Wednesday and be ready to plea sometime in the next 2 weeks.
All right, we'll just do about a 2-week reset. And Mr. Rhodes, make sure you stay in touch with Mr. Parker. He'll let you know when that next court date is, and we'll take care of it. We'll put it on a plea docket on that next court date. All right, free to go.
Thank you.
Good morning, sir. You're Ryan Reamy. And this is cause number 25 DCCR 1246. Mr. Reamy is charged with driving while intoxicated with a child passenger. It looks like just recently there was a motion to suppress filed. Is that something, do you believe, Mr. Comerford, that would be dispositive of the outcome of the case if I hear it prior to trial?
Yes, sir.
Okay, so let's do this. I'll set it for a hearing on that in the next 30 days or so. We'll find a time when we have a couple hours at the most. I wouldn't think it would take more than an hour or two.
Okay.
I haven't looked at it, Judge, but I have a
Okay.
question.
And then we'll, I'll go ahead and take care of that. That way you guys know how to proceed, depending on the outcome of that.
I have a jury trial July 8th, so I just want to make that availability. We can just anytime in July and be fine, just not first week.
Okay,
That-
no, it won't be on a regular date. I'll have to find a date for us to have some time for the hearing. Just make a notation for me and we'll take a look at it. Make, if you'll put not July week, okay. All
Thank you.
right, stay in touch with Mr. Comerford. He'll let you know when you need to be back and ready for that hearing, okay? All right,
Thank you,
thank you. Good morning, sir. Are you Michael Harrison Jr.?
yes, ma'am.
This is 25 DCCR 1859. Mr. Harrison is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, we reviewed the evidence, received an offer, and if you would give us a plea date, needs to arrange some time on the weekends for.
All right,
Sure.
any issues?
No, you're on.
You've got the ignition interlock device. Make sure you keep that, take care of that, and we'll just do a normal reset for a plea on the
Yes,
plea
Your Honor.
docket. We'll take care of it on that day. All right.
Thank you, Your Honor.
Thank
Have
you.
your excuse.
Yes, sir.
Thank you.
Good morning, sir. You're Edgar Castillo.
Yeah.
And this is 25 DCCR 1052. Mr. Castillo is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
If we have a deal worked out, we're gonna need to have a little time to sign everything up.
I'll hold it. You're gonna do that today? Yeah.
I believe so.
Okay. Just have a seat, sir. Blaine Dunnigan, hold that.
For this judge.
And then Toy Frazier.
Boy. Yes, we can reset that with permission from the.
Good morning, sir. You're Toy Frazier.
Yes, ma'am.
And this is 25 DCCR 1494. Mr. Frazier is charged with giving a false name or information or forging a vehicle registration. And what is the announcement?
Judge, we're asking for a little time on that. If we could have a normal reset, so Ms. Bonfino and I can discuss.
I would
details.
agree, Judge. This case actually involves the tax assessor director.
Yeah, I'm just looking. It looks like you were signed on in October of last year, so this will be the final reset. So make sure y'all get together, visit Mr. Frazier. Make sure you stay in touch with Mr. Gertz. Once he gets any information, we'll get an announcement at the next court date. Okay, thank you. You're free to go. Make that notation, please. Good morning, sir. You're Davion Mason. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Mason, in cause number 25 DCCR 1511, you're charged with the state jail felony offense of burglary of a building, and that's from August 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you made is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Mason's not competent?
No objection.
Is there any issue with restitution?
I have the restitution amount, but I would ask the court, please, just
Go ahead and
because of
get
my
one.
prior dealings with Mr. Mason, would you please get a PSI?
Yeah, so
But it's
Mr. Mason,
$2,000. There is a co-defendant that I would make
Okay.
it incumbent upon both.
need
of
some
them.
more information on that. So, Mr. Mason, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If there's any restitution, we'll discuss that on that date as well, okay? On your way out of the courtroom today, you need to stop and talk to the probation officer, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino is charged in cause number 25 DCCR 0096 with credit or debit card abuse. And what is the announcement?
Judge, we have a resolution in place, but it's gonna require some upfront restitution. So we're asking for some additional time for him to come up with that. About 45 days should be enough. For him to do that.
Today's courtroom docket was filled with defendants standing dangerously close to life-changing consequences. From firearm allegations and probation warnings to DWI cases involving child passengers and serious felony negotiations. Throughout the hearing, the judge repeatedly emphasized one major theme: accountability. Whether it was strict no-contact orders, warnings about probation violations, or final reset opportunities before trial, the court made it very clear that second chances come with serious conditions attached. Some defendants walked away with opportunities to avoid prison, while others were warned that one mistake could completely change their future. And honestly, these are the kinds of courtroom moments that show how quickly legal trouble can spiral when poor decisions, repeat offenses, or risky behavior are involved. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Smoking eye?
I have no objection to that. Judge, we've offered to reduce it to a misdemeanor based on his having no criminal history. If he'll pay that up front, I believe it's about $5,000.
So here's the thing, Mr. Charbino, I'll do a 45-day reset. Give you some time. If you can get the money together, great. Sounds like that's a great deal. If for some reason you can't, I'm not going to keep resetting it for that. You guys will have to talk about some other resolution.
Yes,
Okay, so do what you can, but I will give you 45 days on that.
Yes, ma'am.
All right.
Thank you.
Thank you. You're free to go. Richard Volry, it's a sentencing, Mr. Lewis and Ms. Mulkey.
We've got getting ready for this other trial this afternoon.
Good morning. You're Felicia Freddy. And Miss Freddie, this is an MTRP and cause number 24 DCCR 1390. What is the announcement?
Judge, if we could have a few minutes, I think I'll be able to get this resolved today.
Okay, sure. I'll hold
It's
it.
an MTRP, Judge. So.
Thank you. Just have a seat, ma'am. Okay. And then you've got Miguel Martinez, Mr. Gertz.
Yeah, Judge.
You're Miguel Martinez. This is 25 DCCR 0584. Mr. Martinez charged with aggravated sexual assault of a child. And what is the announcement?
Judge, the state made us an offer and we have made a counter offer in the case. And I think the state needs to get input from the family, is my understanding. And so they're not saying no, they're just saying, let us check. So I don't know if you want to do 2 weeks or 3 weeks.
I'm going to do 2 weeks. It'll be the final reset. It looks like this has been about a year.
There is a possibility that I'll be in trial in Lufkin and federal court on that day, but we will let you know.
Just let us know and we can push it a week or two if we have to. Make sure you stay in touch with Mr. Gertz so that once he visits with Ms. French, you guys know, because this will be the last reset for an announcement.